Hi, everybody. Welcome to our webinar, Barriers to Record Clearing Responses from the Field. This is a webinar presented by Community Legal Services as part of our National Record Clearing Project through funding by the W.K. Kellogg Foundation. My name is Katie Svoboda-Kindle. I'm a staff attorney at Community Legal Services in the Employment Unit, and I'm going to be serving as the moderator and also talking about the survey. So I want to start by just talking a little bit about what we're going to be discussing in this webinar. We did a survey as part of the National Record Clearing Project that hopefully many of you have seen, a survey that went out to practitioners who do actual record clearing motions and help clients with record clearing issues. To try to figure out the kind of procedural barriers, the practical barriers that people are experiencing. Because we know that there are some barriers that are evident in the statutes and the laws, but there are some barriers that are very significant that are not necessarily evident in the statute. They're based on practice or they're based on procedural issues that might not be so obvious. And so we wanted to find out what those were like. So we sent the survey out and we got responses from, at this point, we have kind of preliminary results, which we're going to share today, with responses from 30 different states. If you're interested in seeing which states they are, we have two handouts in the handout section here. If you look under handouts, and we'll also provide them via email in this webinar, and one of them is a list of the states or locations. It's actually 29 states in DC that have responded so far. So we're trying to get responses from all 50 states. We're still working on that. But right now, today, we're going to be sharing some of those preliminary findings. And the reason that we're so interested in procedural barriers is, of course, because we know that barriers contribute to the second chance gap, where there are so many more people who are eligible for record clearing than who actually get it. And we want to shine a light on these procedural barriers because we know that lifting even one of the barriers that might apply to you in your jurisdiction could have a big impact, has a very, very big impact on who actually can access record clearing. So I'm going to be sharing some of those survey findings today, but we also have panelists today who are going to be sharing their experiences and their insight about some of these topics. So I want to introduce the panelists now, and then we're going to be hearing from those panelists during the presentation after I present on the survey findings. So today we have with us Akil Roper. He is the Vice President and Assistant General Counsel at Legal Services of New Jersey. Legal Services of New Jersey supports a statewide system of regional legal services programs, and he also supervises the Reentry Project, which focuses on criminal record barriers and record clearing. We also have Josh Spickler. He is the Executive Director at Just City, which is an advocacy organization that pursues smarter criminal justice policies for Memphis and Tennessee. And specifically, they focus on areas like expungement, where poverty is a barrier to criminal justice. We also have Janet Ginzberg. She is a senior staff attorney at the Employment Law Unit of Community Legal Services, and she represents clients on a broad variety of employment issues, including criminal records. She's been there since 1999. So we're going to be hearing from that panelist. We're so excited and I'm very thankful that our panelists are here with us today to share their insights. And we're going to be focusing on four main topics today, which are kind of big ideas and big themes that came out of this survey. First is obtaining necessary records and the barrier that creates. The second is inefficiency and delays. Third is prosecutor objections, judicial discretion, and the connection between those and proving that your client deserves record clearing, because there seems to be a big connection there. And then the fourth is fines, fees, and costs. We are going to have questions and answers at the end. So if you have questions, please put those into the questions thing that you see on your screen. And as I already mentioned, the PowerPoint and the list of states is under your handouts, and we'll also provide that via email. This webinar also will be recorded, so that will be available later. So first I'm going to talk about obtaining necessary records and their survey findings when it came to that. What we found in our survey is that this was the answer to one of the questions: how do you obtain criminal records? And as you can see, the majority of people, 57%, said that it was possible to obtain criminal records online. However, when you kind of dug a little bit deeper about that, the picture is not so rosy. Only 20% of people said that most criminal records are publicly available online. So that really just kind of indicates that records, people who are filing criminal record petitions, record clearing petitions, are still having to access records through other means that are not so instant and not so easy. What we found in the comments were that online records are often incomplete. So paper records are necessary anyway, even when online records are available. They're incomplete in that they're not reliable, the information in them is incomplete, they only have the records from recent years, or you need to get the paper copy anyway. And if you look at a close-up at the respondents who said that they always are required to provide criminal records and to append them to their record clearing motions, that's only 37%. But when you look at that 37%, unfortunately, it's even more difficult for them to get these criminal records. They're more likely to say that they had to get them by mail or in person through a difficult process. And only 9% of that group said that most of the criminal records are online. So it shows for some people, this is a significant barrier. So I just want to talk and open that up to the panelists. If we could begin with Akil, talking about the issues that you've had in your jurisdiction or in New Jersey about criminal records.
Sure. So I guess it's an initial matter. It was always strange to me why the petitioner was required to gather all these evidence and documents with respect to their criminal records and then file it, and then the prosecutor reviews it. So the prosecutor, they have all that information already, but the individual is still required to gather that information and certify to it. So from the start, it almost seems as if you're not on the same footing in terms of getting your applications through. So one of the things I'll say is that we do have a system where we are trying to encourage more folks to get their documents online. And so we do have 2 databases that are available online. The problem is that the databases are not comprehensive. We have one database which has indictable level information in it, but it does not have dismissed cases, it does not have juvenile cases. We've got a separate one which has municipal court level information, which has summons, complaint, warrants, number, things of that nature. But that is limited as well. And you have to be a little bit sophisticated in using these databases. The one place where we typically instruct clients to go is to get what we call a CCH from the state police, which is a state police report, which is from a fingerprint. And so the fingerprints go in, and you're returned a report that should have all of your arrests within the state of New Jersey. But that's not often the case because not all matters are fingerprinted. So that, as a result, we have to do it step by step, and it's not a full service. So we always have to supplement that CCH with the online database searches. Sometimes we're also required to go directly to the court to get those records. So it's a process. And it certainly is a barrier in New Jersey. We are moving towards e-filing, automated expungement, but we're not there yet. And so we have that complicated process right now of gathering the records and making sure you have everything when you do your filings. And we always encourage clients to take care during that process. And sometimes that's overlooked because if you don't have all your information when you file, either one of 2 things is going to happen. Either you're going to file it, you're going to be missing some arrests or convictions or matters that should be expunged. It's going to go through, and those matters will not be expunged, of course, because it was not on the petition, but they'll still exist and cause problems. And if you try to expunge those subsequently, you might have an issue because you've already filed a petition for expungement in the first place. On the other hand, if you file it and not everything is on it, you're going to get an objection from the prosecutor, and that's going to get kicked back, and you have to go through the whole process again. So it's a very difficult process, and it creates a lot of barriers for folks in New Jersey.
Thanks, Akil. Josh, if you could talk about your experiences in Memphis.
Yeah, thanks, Katie. Of all the things that we do in Memphis and Shelby County, Tennessee that don't make sense, we don't require that type of record gathering from people before they petition for expungement for their record to be cleared. So we do have that benefit. What we've seen though are silly things like just questionnaires that the clerk's offices develop themselves. This is not part of the law. It's not part of the statute, and it's designed, frankly, to find money. Questions about bankruptcy filings and work that can lead to garnishment are some of the questions on these questionnaires. So while we have a little bit more of a streamlined process in that we don't have to go and find these records ourselves, because they do, as Akil pointed out, they have the records. They created the record. They certainly have it. Why we have to bring it to them in places like New Jersey, I have no idea. We don't have to do that, but they do find other ways of creating barriers. And in most of those cases, that's designed to help them collect on overdue costs and fines, which is really frustrating.
And Josh, you have developed some systems that make it easier for people to access their own records, right?
Correct. We offer a form on our website that we have linked to essentially a scraper that can search our local database, our local criminal court database, and determine eligibility with pretty high degree of accuracy. And respond automatically if the person leaves an email address regarding their qualifications for record clearing in Shelby County. It's only in our county, which is a large county in Tennessee, but it's not statewide at this point. So yeah, we are able to do that, which makes it a whole lot easier to blast out requests on Facebook or go to large events, because we can put people's name and information in and very quickly get results. We can handle large numbers of inquiries at one time, which is not always the case, and I know it's not the case in a lot of other places. And so it's been a really big advance for us to be able to serve as many people as possible.
Great, thank you. And Janet, could you give some input from Pennsylvania?
Sure. To start off, one of the difficulties in Pennsylvania, as I'm sure in a lot of states, Josh, you just mentioned that your county is different from other counties. In Pennsylvania, counties can have different rules. So there are some counties in Pennsylvania that do require records to be attached. They require people to send for their Pennsylvania State Police record and attach it to the expungement petition. We've been pretty lucky in Philadelphia. In Philadelphia, we do not have to attach any records, and all of our criminal records, statewide criminal records, are easily accessible online. That's sort of an irony, is that when they were put online, I think like 12 years ago, 13 years ago, it made it so much easier for employers and other people to see everybody's records, which necessitated doing record clearing at the volume we do it. But it's also made it easier to both create a generator that automatically creates petitions, and also just the ease of getting documents has made the process smoother. And I would also add that we now have a clean slate law in Pennsylvania where some convictions, some misdemeanor convictions, can automatically get sealed. And that has been facilitated by these records being online and being easily obtainable, not just by individuals, but also for the system that was set up to seal records automatically. And that's been a great boost for us.
Thank you. I also want to mention that according to the respondents to the survey, there are many different issues that come up with records, and some additional ones that we haven't discussed yet are records not being centralized in one location, so you have to go to multiple locations that might be inconvenient to get records. Records having multi-step processes or complex processes to obtain, and fingerprints being required, which of course is just an extra step of things to do. All right, moving on to the next topic, we're going to be talking about inefficiency and delays. So first of all, writing the petition. Mostly we have good news from our respondents here. 77% spend an hour or less writing the motion. 40% spend 30 minutes or less. So if you take a close-up look at the people who are taking longer to write their motions to try to figure out what is going on there, why is it taking so long to write the motions, and there's about 23% of the respondents who take more than an hour, what we see is that they're much more likely to include personal facts about their clients in their motions. So these are the kinds of motions where you have to prove that someone's been rehabilitated. So obviously that takes longer to write. They're less likely to be using technology to assist with motion writing. So we've already heard from Janet a little bit about the expungement generator that we use here in Pennsylvania, or at Community Legal Services, and is actually available to everybody in Pennsylvania, to automatically generate petitions, or at least fill in. There are different technology that you can use to fill in the blanks of petitions. So people who are spending more than an hour are much less likely to be utilizing things like that. A third thing is that they're more likely to be including court record documents with their motions. It is not an issue of, according to the survey results we've gotten so far, it's not based on them having to include more legal arguments or more complicated arguments, and it's not even correlated to whether there's a form petition available or not. Another place where we see delays are, of course, the delays caused by obtaining records. 53% of our respondents said that they wait more than a week for records. 26% wait more than 2 weeks. And again, I refer to the 37% of our respondents who said that they have to append records to their motions. They unfortunately wait even longer for their records. So 64% of those folks said that they had to wait for longer than a week, again showing that that is an even greater barrier for them. We also have inefficiencies obtaining records, that it just makes it more difficult to write these motions. 43% of our respondents spent more than an hour collecting documents and information. And if you take a closer look at that 43%, what's going on seems to be that they are the records are more difficult to obtain, so they're more likely to say that they were obtained through a difficult process. Only 14% said that most records were online. But maybe the biggest difference is actually that these are people who are having to include personal facts about their clients in their motions. So it seems like they're actually spending time collecting information about their clients, and that is a very work-intensive process. We also are seeing delays after the petition is filed. So 37% of our respondents say that it takes 6 to 9 months from the time the motion is filed to the time that the record is actually removed from the relevant databases. 10% said that it's more than 9 months. And according to the comments, the problem that people are seeing is that the law does not require the courts or the agencies or the offices that are in charge of removing these records to abide by any kind of deadlines. There's no deadlines in the law, and it isn't a priority, so these things get pushed back and pushed back. And lastly, when we asked about whether there was any kind of judicial efficiency happening, anything the courts were doing to make it more efficient, only 40% said yes. Some examples of judicial efficiency that people provided were that in their jurisdictions, hearings were waived, there was a designated judge or a designated clerk, and they would also set hearing dates immediately. So I just wanted to open up to the panelists now. If we could maybe hear from Josh about the kind of delays that you experience in Memphis.
Sure. Thanks again, Katie. We do have some of those streamlined, some of those efficiencies as well. We have a dedicated clerk in both our general sessions and our trial courts. So it's in Shelby County, and so that does make things pretty quick relatively speaking. And most of the record clearing that we do at Just City is sort of follow up on diverted sentences where people have been unable to pay the fee. And so those are particularly simple to get accomplished. The clerk generally handles that. There's no court appearance, there's no petition. So most of what we do is very different from the kind of thing you're describing. Across Tennessee, it's very different. I hear stories from attorneys in rural counties and other areas where, you know, everything is a hearing and everything is drawn out in a much longer way, similar to what some of these results are telling us. The delays we see are when we do have to depend on the district attorney. When Tennessee expanded its expungement eligibility a few years ago, they, in an attempt, I think, to allow people to do this without counsel, put the onus on the district attorney's office to do this. And so as you can imagine, they're not committing a whole lot of resources to this. And so that's where a lot of our delay ends up, is when we do have that 15 or 20% of cases that we need the district attorney's kind of sign off. And generally, if person's, you know, qualified under the law, we don't have to have a hearing. We don't have a lot of pushback, but we do have to wait, unfortunately. It's an area that's ripe for challenge, frankly. I think the law allows us to petition ourselves. I don't think we have to go through the DA. They are of the mind that we do. I think that's just because they are of the mind that everything should go through them. But so we haven't challenged that here, and I'm not aware of anywhere in Tennessee. But that's where we see ours. And then just the typical, you know, government service slowdowns, clerk's offices can be slow, and that's what we see. And so we see some of those same time periods in wait when we need the order and we need the actual record erased from the system. We're waiting weeks and weeks.
Thanks very much. Akil, could you give us your input?
Sure, thanks. I think the court is not really the logjam here in terms of folks getting their expungements through. I spoke a little about the CCH process of getting your fingerprinted records, and most folks do that. They get their fingerprints from the state police through an outside agency, and that takes weeks. In addition to that, when you file your petition for expungement, it goes to the prosecutor, and then the prosecutor goes to the state police, and they have to review it again. So the state police does another review, and it takes them many, many weeks to do this. And once again, after they've gotten their expungement, at least the order signed back from the judge, it has to be served on parties, and then the state police, again, they have to effectuate the expungement. And again, that takes many, many weeks. So that has really been the major source of the delays, the state police. But even in the process itself, we talked a little bit about gathering documents, how that can be time consuming in a number of different ways, including if you have to file an amended petition if you didn't have all your information in there. And then the petition itself, it's it's not rocket science, but you're requiring an individual to file something with the court. There's a little bit of intimidation there, and then you want to make sure everything is right and perfect, and of course you do. So you take a lot of time, and a lot of details are required in these petitions in New Jersey. We don't require the evidentiary pieces, proving up the rehabilitation. That's typically not required in New Jersey, but you do have to have all of your ducks in a row in the sense of having your entire record detailed from A through Z. Even if you're looking to expunge certain things off of your record. And that I would point to also. So in New Jersey, you have the ability to expunge dismissed cases. You can expunge disorderly persons, up to 5 of them now. You can expunge indictable convictions, and even certain additional ones if you have a crime spree or if you have a drug court expungement. So the law itself is getting a little more complicated, but you're still required to pack in all that information as the individual has had multiple contacts with the criminal justice system, and that takes time. Sometimes we're talking about records that are decades old sometimes. So having to gather that information again is certainly a barrier for folks to getting that expungement.
Thanks. All right. So moving on to our next topic, we're talking about prosecutor objections, judicial discretion, and proving rehabilitation. And as I mentioned in the beginning, really we see a connection between these topics, which is why we put it together. So 77% of the respondents said that prosecutors sometimes or regularly object. So objections are still pretty common according to our survey results. And if you look more closely at the 77% that say that prosecutors sometimes or regularly object, you see that they are more likely than the general group of the larger group of respondents to have to include personal facts about their clients. So that kind of indicates that what the prosecutors are objecting to is whether the client has been rehabilitated. As a side note, incidentally, this same group is still very likely to be to succeed in their motions. So even this group that says that the prosecutors are objecting, 83% of them say that they're regularly or almost always winning their motions. According to the comments that we received, there seemed to be a theme that, you know, the judges and prosecutors are just not reflecting the will of the legislature, because the legislatures in a lot of states have been expanding record clearing, have been showing that they want more people to qualify for record clearing, and that these judges and prosecutors are just not getting the memo. They're not acting according to that, and they're still objecting. Now we're widening our view to the whole group. So out of all the respondents, 60% said that they had to include detailed facts about their clients, at least sometimes in their motions, for example, to prove rehabilitation. And if we take a closer look at that group, we're seeing the same, first of all, we see the same correlation from the other direction. So much more likely to say that prosecutors at least sometimes object. And also we see just how much more burdensome this kind of motion is and motion practice is. So they're more likely to not utilize technology. Perhaps, I mean, that might be because maybe they don't see that it's as worth it, or maybe that's something that that those jurisdictions should be looking into, because we see that people who are using technology to create their motions are spending less time. So even in those jurisdictions, perhaps that is something that they should, you know, be interested in maybe exploring. We also see that it's taking them longer to collect information for a petition. 60% say it takes longer than 3 hours. 40% says it takes longer than 5 hours. And they're also much more likely than the general respondents population to have to go to court themselves and to have their clients go to court. So we see just how much more burdensome this type of motion practice is. So if I could open it up to Janet, if you could give some input about practice in Pennsylvania and how it relates to this.
Sure, and again, I can only really speak to the county and city of Philadelphia, because the counties do things differently. In Philadelphia, you know, prosecutorial discretion, sort of by definition, depends on the prosecutor. We have a new prosecutor who's been in for about 2 years now in Philadelphia, who comes from a civil rights and criminal defense background. And under him, his office set up a system where the motions just go to them automatically. We don't have to put in anything about rehabilitation. We don't have to put a lot of details. They have people committed, dedicated to looking at the crime and objecting or not objecting, and they rarely object. But 2 years ago, before Larry Krasner became our prosecutor, we were going to court all the time. The prosecutor before him objected regularly, and we would have to bring our client into court, and we would have to prove what we called the Wechsler factors, which was a balancing test of, you know, showing rehabilitation. The prosecutor had the burden, but they had to show that there was a pattern. They had to show the state's interest, and we would have these pretty much full-fledged hearings all the time of having to bring our client in and show these factors. And we won most of the time. Occasionally we didn't, and sometimes we'd appeal the case. But, you know, it just sort of shows that the prosecutorial discretion can come and go. And sometimes will be used in one way, and sometimes will be used in a way now which has drastically streamlined the process, and which we think is more in keeping with what the law says about the right to expungement in Pennsylvania. So hopefully we'll have this prosecutor for a while, but even hopefully after him, we hope that this system will remain in place and that the next prosecutor will agree that this is a fair and equitable and efficient way of dealing with prosecutorial discretion.
All right, thank you, Janet. So our next section is just kind of talking about a myriad of different burdens and requirements that were identified in the survey that I want to just review, because I think in some jurisdictions they really cause a significant burden or are a significant burden for filers. First of all, we asked the question, what do you think is the most significant barrier in the place where you practice? And 43% of people mentioned the complexity of the law, which of course makes it more difficult to file motions for lawyers, but makes it much, much more difficult for the public to understand if they qualify, and for pro se filers. 37% mentioned money, so costs or fines or fees. 23% mentioned the limited application of the record clearing laws, just that the laws really don't cover very many cases or very many people. 10% mentioned the waiting period for record clearing. You have to wait 10 years or sometimes longer before you're eligible. 10% mentioned the difficulty of obtaining records, which we've already discussed, and then 6% mentioned the lack of public awareness. We also asked a question about whether there was anything that you had to do before you actually went to court and this thing was granted by a court, which is the procedure in most places. What kind of administrative review or pre-hearing review had to be done. And this is only true for only 30% of respondents consistently have this, but it appears from the comments that the jurisdictions where this exists, the administrative process is very, very burdensome. So people told us that there were months-long delays that were caused by this, that there was a significant cost. In some places, it's hundreds of dollars that people have to pay to get this review done. And in a lot of states, there's no ability to appeal. So in some states, you can file the motion anyway, even if the administrative review is, you're denied through the administrative review. But in some jurisdictions, in many jurisdictions, there's really nothing that you can do if you're denied. We also asked about pro se petitions. Unsurprisingly, 83% of people said it was at least somewhat difficult for pro se individuals. And from the comments, it seems that people are mostly thinking that are concerned that people are unaware of the law. Generally, they don't know that it applies to them. The resources available are not sufficient. The law and the filing requirements are too complicated, and just generally is intimidating. Just having to appear in court is intimidating for pro se individuals. We also asked about service requirements, and 70% of respondents said that they at least have to serve the prosecutor, and most of them use mail or in-person delivery to do so. So most of them are not using any kind of automated process to serve. They at least have to, send an email. And in fact, most of them are using kind of snail mail or in-person delivery. So that not only puts another burden on the filer, but it's very, very difficult for pro se filers. We also asked about the effectiveness of record clearing. So how effective is it at actually getting the record removed? So only 20% of our respondents stated that they were required to notify parties after a motion was granted to get the record removed, but more said that they do so as a practice. They're not required to do so, but it's recommended to do so. It is more effective if you do so. So more than 20% are actually doing it. 37% of our respondents said that they regularly see cleared cases on background checks. And out of that group, the vast majority said that they saw it on commercial and private background checks. From the comments, people are identifying that the issue is that the commercial background checks are using stale data. So, the states do have a method where the state database is usually more accurate. But there's no method in the vast majority of states. There's no method for the state to proactively tell these commercial database commercial, the credit reporting agencies, that the record clearing has occurred, and so they're using old data, and they're reporting these the cleared cases. So in most places, it's up to the individual to monitor their own record and to challenge their record individually. All right, and then our last topic that we want to discuss is fees, fines, and costs. Okay, first of all, when it comes to records, most of the respondents identified that there were at least sometimes fees for records. So 70% of people said that there were always or sometimes fees. From the comments, we heard that those costs have a very large range, from $5 to $160. Oftentimes there's fees per page. So if someone has a long criminal record, it could certainly add up. We also have filing fees. 60% of our respondents said that there was always or sometimes filing fees. And again, those costs have a very large range, from $30 to all the way to $650. 70% said that filing fees were routinely waived for indigent filers, so that is good news. There are also other fees that people identified, administrative process fees, as I've already discussed. So those places where you have to get it approved by the prosecutor's office or by the state police, that costs money. Fees for making copies, fees for service, and fees even for effectuating the record clearing after it's granted. So in some places, there's fees you have to pay after the motion is granted to actually get the record removed. When it comes to court fines and costs, the vast majority of the respondents are saying that at least some court fines have to be paid. So only 10% are saying that no fines or costs have to be paid before a record can be cleared. 50% say all fees on the case have to be paid. 17% say all fees on all cases have to be paid. And then 23% say that sometimes fees have to be paid or some fees have to be paid. And from the comments, we learned that even in these places where the statute doesn't actually require fees to be paid, the judges are using their discretion to require it. So they will deny a motion based on the fines and costs not being paid. So I want to open this one up to the panelists. If we could start maybe with Josh, and you could talk about your experiences with fees, fines, and costs.
Yeah, of course. One of the, what I would have said 2-3 years ago, the biggest barrier in Tennessee was the total $450 cost to file for a record to be cleared. It was made up of a mandatory local clerk fee of $100 and then a mandatory state fee of $350. Neither of those had indigency exceptions. And so it's really kind of almost how Just City, the whole organization, got its start with our Clean Slate Fund, raising money to pay that. So not only did we have this really complicated and confusing procedure and qualification process, but we also had a pretty exorbitant fee, one of the highest in the country, we found. And so while we were raising money and paying those, we were also working at the state capitol with a lobbyist and a small coalition of like-minded folks to get that fee reduced, with the argument to the state that you are really restricting the demand that is out there. I mean, we saw that in numbers. We saw the year after they raised the fee, tripled it, overnight. The next year or two, the expungements just slid off a cliff because no one could afford it. Happy to say that our governor signed a bill last year completely eliminating the state version of that fee. So now it's just a $100 local fee that is unfortunately not discretionary. I know our local clerks would both waive it if it were. So we're looking into addressing that if and when our legislature ever opens back up. So that's been one of the biggest victories we've had in Tennessee, is getting that fee down to something much more reasonable. Groups like ours can go a lot further with our money when it's $100 per, and people can do it themselves. I would add one more thing, and that's that as of late last year, we've had a fellow here from Equal Justice Works, a recent law grad, who is now systematically addressing this idea that people can't get the expungement done because of court costs on the case that they're attempting to be cleared. And it's by far and away the biggest reason that people are not qualified in our county and state. And so there is discretion on those costs. And so we are working through our hundreds and hundreds of people on our waiting list to address the courts individually on waiving those fees. And we're having some success. Obviously, it depends on every judge, and some of them are doing what you described, Katie, of requiring some payment or a purge payment of some sort. They're extorting as much as they can, and some don't mind at all waiving all of it. And that does require a lot more work than just the expungement process. But we're beginning to see a lot of fruit from that. At least we were before courts shut down. And so we hope to get that back started as soon as our courts open back up and get even more people qualified, because costs and fines are a huge, huge problem.
All right, thank you, Josh. How about you, Akil?
Sure, Katie. Similar to Josh, we recently passed a law eliminating filing fees. They weren't $450. They were about $75 for a filing fee, but of course that's a substantial amount of money, particularly when we're talking about low-income folks that are our clients. So that is good, but on the other hand, we still have a lot of costs associated with the expungement generally. So in addition, we talked about the state police record, the fingerprint record, which costs about $42. There's that, and then there's also service on a number of parties, which can go up to about a dozen. So after you file, you have to serve it on a number of notice parties and agencies in the state. If you have to be up to 12, could be more. And that comes at a cost because it has to be a certified mail return receipt requested. So that's $7 a pop, coming and going. So you have to serve that return receipt requested on those parties, and then additionally you have to serve, if you get an expungement order, you have to serve the expungement order by a certified mail return receipt requested. And those costs ramp up as well. In addition to making all those copies for all those parties you have to serve, all that paperwork, it's a huge expense. And sometimes that is certainly a barrier for our folks. Now, in terms of the underlying fees and fines that have attached to the criminal justice contacts, there are mechanisms in place in the law, which we're very grateful now that we have those in place that allow that to be relaxed, in the sense that they don't have to be fully satisfied before you can get an expungement. Now, typically you have to be on a court payment plan before you can be eligible, but as long as you're not in willful non-compliance of a court-ordered payment plan, you may technically be able to get your record expunged without having to pay that the fine in full. But this also ties into the complexity and the awareness piece, because the trajectory of our expungement law, it's usually, it moves in more in favor of increasing or expanding eligibility over time. So for the long time that I've been doing this, since 10 years or so, every few years that law gets amended, and it broadens that eligibility. But as that happens, we have to make sure that we are making our clients aware that the law has changed, which requires a lot of outreach to the community to explain all these changes, because there's a lot of misconceptions about the law and what really applies. So I think that ties back. But in terms of fines and costs, absolutely. The cost of getting an expungement is high still, even though we did get an opportunity to eliminate that actual filing fee cost.
All right, thank you. And Janet?
Well, here as well, fines and costs are a huge barrier to getting the records expunged. We do have filing fees of $147 per petition. In Philadelphia County, at least, people can get informal papyrus, and legal services clients in Philadelphia can automatically get IFP and not have to pay the filing fees. But I know that's not true across the state, where they're still fighting to get the courts to accept some IFP motions. One thing that we see where fines and costs are a huge barrier, I had mentioned earlier our clean slate law. Fines and costs have to be paid off before a case will be automatically sealed, or even sealed by petition, which is another route. So, it's such a great law that would, has already cleared something like 30 million cases across the state, and it would clear a lot more if fines and costs weren't such a huge barrier. And in our case, in cases of people in Pennsylvania, certainly in Philadelphia, it's often fines and costs that they don't even know still exist. You know, they thought they'd paid everything off, or there were supervision fees that they didn't know about. So here as well, it's an issue that we constantly have to work on.
All right, thanks. So as an ending note, we're going to end on some good news from the survey. First of all, just some kind of anecdotal things from different states about things that are good happening around the country. There are some states that identified that they do actually have pretty expansive or liberal record clearing laws. There's a state where maybe multiple states where the judges have discretion to grant a record clearing petition earlier than that statutory period. We already heard from Akil about New Jersey, but that there are no money has to be paid in order to get expungements granted. There are states where they're using online tools and automation to make record clearing more effective. And then there are some states where lawyers are being made available and paid for in some in Texas by the county to assist pro se filers. And last but not least, a piece of good news is that there is a lot of success happening. So 86% of the respondents to our survey said that they are almost always or regularly winning these motions. So despite all of the barriers and the burdens that are here, we are still prevailing, and that is the best news of all. So now I just want to have some time for a few questions. First, I just want to follow up with a question for all the panelists. So you all mentioned things that have changed actually in your jurisdictions. Burdens that used to be there and have actually been removed or have been improved. The situation's been improved. So I wonder if each panelist can give us an example of something that has improved in their jurisdiction and how that happened, what role their organization might have played in making that happen. If we could start maybe with Akil.
Sure. So I guess the answer to that is relationships and outreach and public awareness. So we try to do a couple of things, and one of the strategies is to work closely with the courts. And we have been working with the courts quite a bit ever since we did our Clearing Your Record Online manual, which has now been transformed into an online tool to help folks determine their eligibility for expungement and then generate documents which they can use to file their expungements. And we work with the courts very closely in developing these tools, and we've done a lot of outreach with the courts, expungement seminars, CLEs, and so forth, getting information out there and making sure we have a seat at the table, so to speak, when we're considering new ways to improve the law and improve the process for folks who come through our doors. And similarly, I think having relationships with legislators has been helpful to us as well. I mean, there are key legislators in our state who have focused on criminal justice, they focused on prisoner reentry, those types of reform. And so having relationships with them to be able to sit down and explain things and break it down exactly the impact of expungements and why they're important, and why people are being denied expungements, why certain people are being denied expungements and other people are able to get them granted. So having those open doors to be able to have conversations with people who are well situated in places to help make those changes possible, I think has been key.
Great, thanks. How about you, Josh?
Yeah, similarly, relationships are key, and I would, credit our lobbyist, which is hard for me to even say, but he is amazing, and he has done a lot of really good, deep work at the state capitol over the last 4 or 5 years. It's painstakingly slow, but I have, from a little bit from afar, watched, the lawmakers in committees talk about this issue very differently. because of the work that he's done in the background and because of the data we've supplied and the stories we tell them when we go up there and sit down with them. And so, in fact, this year there was a bill that was kind of a wish list of sort of tightening up small things across the code that we didn't pursue. We had it in a package in the past, but one of the newer lawmakers picked it up and presented it himself. And it was not a major overhaul by any means, but very useful, smart legislation that can make it easier for us to do our job and make it easier for people to find relief. And then locally in our community, it's just making this a part of our conversation within government, within our communities that are hardest hit by mass incarceration in the criminal legal system. And making expungement part of that dialogue has been some of our best work, I think, and most exciting. And you see other organizations addressing expungement in their own way, whether it be the clerk's office or the city mayor's office. And so we certainly count those as a success. And I'd say the biggest and most heroic efforts, honestly, are made by the people that we help. We don't ever tie our help to any sort of public speaking or making their story public, but occasionally we will have an opportunity and I will reach out to a handful of people, and they're the bravest souls in the world, because the whole point, as you know, of clearing your record is so you don't have to address your record publicly. And some of the most incredible fundraising, honestly, we've done, and some of the most incredible numbers that we've seen have been in response to some of these brave former clients who are willing to say what expungement meant to them and walk the community and walk the audience through how difficult life was, and then what a turning point record clearing can be for people, and including in our own internal organizational health. Getting an email from a person who is standing in front of a home that she just bought. I mean, that's the story that we tell all the time internally at Just City, is really encouraging for our organization. It means that what we're doing is important, and it really can change things over time when you have more and more stories like that. But it's their bravery and their willingness to reach back and help others that has really been my favorite part.
Thanks. Janet?
I think what I would add to what Josh and Akil have said, because the relationships that we've built with the courts and the DAs have been so important, and even beyond the individual relationships, I think has been the coalition building. That it's one thing to talk to the courts alone and to the DAs alone. What I think my organization was really strong at, that really made enormous improvements, was getting them all to the table together, for them all to agree on what can be done and why it's important. I mean, getting people to understand why expungements were so important in the first place was a huge hurdle, I think, that my organization handled very well. And I will just say that I think if COVID-19 has done anything to our clients, it's set them back a lot. And I think that coalition building is going to be ever more important going forward. We're going to have such a high unemployment rate now that we're going to have to be going back to those coalitions and, keeping the necessity for record clearing on a front burner, because I fear that it is at risk of being put on the back burner now.
All right, thank you so much. So now I'm going to turn to Jessa from our office with some questions from the audience.
All right. So the first question, someone is wondering what the panelists think is the ideal policy that states should have with regards to which documents are required for filing and what the process should be for obtaining them.
I mean, again, I'm sort of shocked when I hear folks from places like Pennsylvania, New Jersey talk about this aspect of expungement. It's baffling to me that the system, that the office, the very clerks who are charged, it's their job, right? A clerk's job is to keep and maintain records, are requiring you to bring that same record to them. To me, and this is much like my opinion on the filing fee itself, was that zero is the really only acceptable cost of this, because in Tennessee, at least, because of the minor nature of it and what it means to people. I would say the same for document production. Why do you have to bring any document? We can talk about service, we can talk about hearings and all that stuff, but it's very clear what it is. It's a unnecessary barrier that's been put in place. So that'd be my response. But of course, I come from a place where we don't have to do that anyway.
As you know, I couldn't agree with you more, Josh. I think that was my initial comment. It always bothered me that was the case, that the individual who doesn't have the documents in hand is required to just provide the documents to the people who have the documents. So, but I mean, aside from that, it's always been my vision in a certain sense, to have some type of automated system for expungement, similar to Clean Slate, right? Where even if you're not aware, even if you don't have the money to get your expungement, if you don't have the lawyers, even if you don't have the ability to fill out a petition, even if you don't have the wherewithal to gather all your documents and put the petition together, file them, serve them, go through this multi-step process, you can still get your record expunged because it's the law. So I think that's the vision of where we want to go with it. Now, that being said, that doesn't mean we have an automated system and everybody can go about their business and not worry about expungement anymore. I don't think that's going to be the case. But that to me is a more fair system where you don't have to deal with all these barriers. You'll have different barriers, certainly, but you won't have to deal with these barriers you've been talking about today. And that's the hope, and that's the vision, the goal. We're taking steps toward that in New Jersey. Obviously, in Janet's jurisdiction, they've taken greater steps in statewide. But in New Jersey, I think I'm hopeful that the COVID situation, where folks are unable to go to the court, they're unable to get justice by walking to the court. They're developing these automated systems, and those will be in place. And we hope that the digital divide will not leave a lot of people behind. But I'm hopeful that the efficiencies can be duplicated and replicated in the sense that it'll make a process in place where we can increase the access and we can remove some of the barriers that is inherent in the petition process. It's funny, the motion. It's a motion that you refer to it as, Katie, and we refer to it as an application, but it certainly is a motion. You're asking the court for a relief, and it's a legal process. It's not as simple as writing your name on an application and handing it in. It's a multi-step process. It creates a lot of barriers for a lot of folks, and hopefully we can get to that place where it's an automated system where the law says you're eligible for expungement, you get the expungement, period.
I just want to actually follow up on that. I see that we actually have an audience question about specifically automated sealing and expungement. And since you brought it up, Akil, it seems like a good time to ask it now. How can automated sealing and expungement do away with these barriers? What role does that have? And is that something we should be working towards when we're thinking about reducing these procedural barriers?
Well, I mean, I think I spoke to those points, but when you break it down, and as we've been through the discussion today, there are multi barriers, a lot, and these barriers are inherent in the process. And so you may or may not have the money for either filing. You may or may not have the ability to file your papers. You may need lawyers. I think an automated system, or the idea is to set all that aside and just directly put an individual in process to get that record expunged after they've met a certain time period. Now, on the other hand, depending on the complexity of the law of your jurisdiction, that's got to be dealt with. So in New Jersey, typically you'll be eligible for expungement after you've met a certain waiting period and completed certain aspects of the sentencing. You've completed your probation, you've completed your parole for a certain number of years, and you've paid your fine. Now, there are mechanisms to relax that, but we're going to have to deal with the fact that it may or may not be tied to one variable, which I think we can do, but it does make that complicated in certain jurisdictions. But again, that being said, I think that an automated process is one. And it may not look the same in every jurisdiction, but I think we should be thinking along those lines in order to try to remove some of these barriers for folks.
All right, thanks.
And if I can just add to that, anyone in my office will tell you that I'm not great with technology and not a huge fan of it. But I will say that when it comes to automated methods for clearing records, whether it's through sealing or expungements, computers are amazing things, right? Almost all states now, I think, have their records on computers. And however they set up their law, whatever the requirements, the eligibility standards for automatic record clearing is, computers can do it, right? They can set up programs that, you know, scrape data and look for data fields in ways that I think, you know, will hopefully make record clearing, automated record clearing, you know, easier and easier as we go along.
And Janet, can you just speak to, since Pennsylvania does have a clean slate automated sealing law, you know, what we've actually seen in Pennsylvania as far as these procedural barriers and how they've been affected, or how clean slate is, you know, breaking down those barriers?
Well, you know, for the cases that are eligible and the charges that are eligible, you know, it's been really great. Again, fines and costs have to be paid on the case that's going to be sealed. But, you know, as Josh and Akil were talking about, that people shouldn't even have to go and, you know, even people who don't know that they've still got the record, or people who, you know, have forgotten about their records, that, you know, they don't have to pay anything. They don't have to file anything. They don't have to see a lawyer. They don't have to go to court. It's just for the charges that are eligible, it's just automatically done. And, you know, in terms of all these barriers that we've been talking about this afternoon, you know, most of those are done away with through an automated sealing or expungement process, whichever way a state wants to do it.
Great, thank you. Jessa, if we have some more questions from the audience.
Sure. We have another question about data collection. So this person is wondering if any of your organizations collect data specifically about the impact of the record clearing work that you do. And if you do, how do you collect that data? And do you get any funding to collect that data?
I can answer that. We do collect some data. You know, we have our client database where we've got problem codes and some ways that we can fill in information about what's been resolved for that client. You're getting me a little close to that technology thing that I've already told you I'm not so great with, but we do collect some data at CLS.
On a couple of occasions, we've tried to collect some meaningful data about the impact. It's very difficult for a lot of reasons. We didn't get a large enough data set to do anything really meaningful with it, but I mean, the results were what you would expect. Lives improved, earnings improved, job prospects improved, but it's the answer to the question, we've never had funding to do it and never had a lot of capacity to do it. It's been something that, you know, we'll use a social work intern to try to reach out to as many people. It's certainly not scientific.
And I would say that I guess similar to Janet and Josh, we have a case management system. So we have a CMS, which warehouses all of our case data. And from time to time, we will have interns do a review. And I recall on certain instances looking back through some of that data to see whether we could find links between those who had drug-related convictions and race. So to try to match up that data to see whether there are additional barriers being put into place, because New Jersey has a very strict law against getting drug sale and distribution offenses expunged. I'm not sure why it has been, but they're lumped into violent crimes. So it's always been difficult to get those things expunged. And it was our impression that, you know, perhaps you know, urban minority communities were the ones getting hit with these charges and convictions. and we hear about this on a policy perspective. So we did go back to our CMS to do a little bit of that digging internally, and that helped fuel a little bit of our advocacy. But at the same time, the cases that come through our doors are not the entire universe of cases of folks who are filing expungements of low income even. So it was a snapshot at best. But that being said, it was helpful in doing that type of review to help maybe shape some of our advocacy or get us thinking a certain type of way. The other thing that I would probably point to in terms of data is something that Josh mentioned, is that one of the things we do to try to fuel our work are client stories. And so we try to pick out client stories that have the most impact. So sometimes we'll go back through our cases and try to find inspiring stories. I tell folks all the time, one of the most rewarding things for me is, we help an individual through an expungement and then they call back and say, I got the job or I got the occupational license, and they've moved on and they're doing great, wonderful things for themselves, for the family and the community. They're volunteering, they're doing this. And I always wish there was a way we could publicize that more, but Josh, his fingers on the pulse with the difficulties of that, because you expunged your record. So you don't want that put on blast in the newspaper. The fact that you got your expungement, it implies that you got a criminal record. So we always have been very careful doing that. But at the same time, it's something that we as advocates, I think we should be appreciative of the fact that expungement is really life-changing work. And I think having some platform to share those stories, even if it's not in a identifiable way, can make impact, I think, for sure.
One more word on data, if I can, and then the biggest, probably most important thing we track are inquiries. We don't get them all, but we get much more than we used to, and we track every one. And it's very useful for showing the need, just to statewide policymakers, but also locally to see what the drag on the economy that the criminal legal system can be for years to come. Of course, we track things like the number of years between the conviction and the expungement, which illustrates how long people are struggling with this before finding relief. But I think the most important thing at any group that we're speaking to about this is, 12% of people that reach out to us qualify. And so saying no is a part of our culture, and it needs to be understood that the vast majority of people who are desperate for relief don't get it.
All right, someone has a tech question. They're asking if anyone has a good resource for creating an online system for production of pro se petitions.
Yes. What we used in New Jersey was, well, we have developed. We're lucky enough to have some developers on staff. We support the statewide legal services network, so we do have some resources, some tech resources to play with, for lack of a better term. So they've been really good in seeking out methods to create some really cool interactive online web tools for folks to A, help determine their eligibility for expungement, and B, to actually create the forms that they will then sign, have notarized, and be able to file for their expungements using that those tools. We use a program called A2J to do the interviews. So if folks go to the website, they can go through an A2J interview and answer a number of multiple choice questions and get an eligibility assessment. And then they can also put in information on a secured site to have that information put on a PDF and email to them as well. But we also had to do a little bit of our own creative writing in order to get, it's not a hot docs document. So we had to do a little bit of creative writing to get the forms exactly the way we wanted them. So I guess if we had Pedro, our tech guy here, he could answer that question a little better than I can. He's much smoother than I am. But yes, the answer to that is yes. We have tech has played a big role in some of the newer the products we tried to put out to help on the pro se sense to help folks who we can't reach.
Okay, and following up on that, actually, that dovetails into advertising our next webinar, which is next Wednesday. We're actually talking about the use of technology in record clearing. And as has already been mentioned a couple times, there is definitely a connection there, right, between making this a more efficient process, using technology to make it a more efficient process, whether it be by automated sealing or through automated, automatically generated petitions, or assisting people in generating petitions. So I think at this point we should just start closing up here. We're already 15 minutes over the hour. So I just want to thank so much the panelists. This has been such an interesting conversation. And we're very, very lucky to have your insight here. And I just want to remind everybody that we are doing these webinars every Wednesday afternoon. We have 2 more coming up after this. And you'll get the registration link with the follow-up email to this webinar, which will include the PowerPoint and the list of states that have responded so far. If you are from a state that is not on the list, please fill out our survey so that we have a response from your state. We would really appreciate it. We're trying to get all 50 states represented. And I want to thank everybody for joining. And with that, we will say goodbye.
Thank you, everyone.
Thanks, everybody.